Hello, everybody. I'm Jay Lazega, joined today by my good friend Jamie Lyons. Hi, Jamie.
Hello.
Welcome. Welcome, everybody, to this session of L&J's Morning Break. We are glad you're here. Hope you've been enjoying these. Thanks for all the great positive comments. The earlier ones are available on our website, and feel free to look at those, share them with your boards. And we're excited about them. We're proud of them, as well as our blogs. So today we're going to talk a little bit about COVID coronavirus issues, but Ross, you can also talk about non-coronavirus issues. And while everybody's been focused right now on probably polls for most of us, the reality is a lot has been happening in our community association world, and a lot happened literally right before the pandemic that's really impactful for us. So we're going to talk about those. We know we still have, pandemic or no pandemic, the obligation to continue to operate our communities, and that means enforce covenants. And we still have maintenance issues, ACC issues, pet issues, leasing issues, and some really, really big things happened in those areas in the last 6 months. So we're going to talk about those. But first, we want to kind of close out some discussion on amenity openings. We spent a lot of time talking about protocols, and I think everybody knows, the reality is that we can use things like signs, and certainly should, signs, disclaimers, protocols, policies. They need to be part of our opening procedures and discussions and evaluations. And we know a lot of our boards are frankly opening, and some are doing it this weekend, and some are delaying. So one of the things that we wanted to do is have a practical conversation about when that should be, in our opinions, and what it means to open. We talked about the need for specific standards and guidelines, and the reality is that regardless of what we may put up in signage and warnings we may put up, the reality is we know we have an obligation to maintain and operate our common areas and amenities in a reasonably safe manner. We have to keep them reasonably safe. And what constitutes reasonably safe has changed in the pandemic. And we get some guidance from CDC, from various health departments. Some of them have started putting out their versions of protocols for opening. And from Governor Kemp, who issued another order just this week. Constantly these are constantly changing, but we're getting some guidance with gyms, for example. The recent Governor Kemp order clarifies that we don't necessarily have to staff a person on site, although we know we still have obligations to sanitize and clean. Similar with pools, we know we have obligations to continue to maintain distancing and to implement cleaning procedures. But what is lacking is specifically, what does that mean? Does that mean every hour? Does that mean between every touch? Some of the ambiguity created in Governor Kemp's most recent order talks about daily cleaning in some circumstances, but then cleaning between each use for some shared items in some circumstances. So we're actually in the process of finalizing some suggested standard signs and protocols, and even for some communities that use them, release agreements that we'll put out in our blogs. But reach out to us with your community, specific communities, and we'll get you information. We'll talk about those. The reality is there is no one size fits all on this, because going back to what everybody knows is Jamie's favorite answer to every question.
It depends.
It depends. We don't know if every community has the same provisions on what can we restrict, what rights do we have, what limitations do we have. Can we restrict guests, for example? We think generally yes, unless our covenants say something that prevents us from doing that. So there's no one answer fits all. So reach out to us and we'll help you with those. But we're trying to put together some uniform things. Specifically as to pools, there are 2 points that I wanted to raise. We want to raise that, for me, are the answer to whether we should open today, and why my answer is no. And that it's frankly, we should wait until we are very comfortable, not only that we've implemented the protocols and the methods for enforcing them, but people have asked about this, and here are the two issues for me. One is insurance, and one is reality in the world of defending lawsuits. Insurance. Of course, every policy and every coverage is different, but there is a common thread or theme that we see in insurance policies. And that's that we understand, I think everybody, we've got a couple of different insurance policies that defend us for various claims. And one is our general liability insurance policy, which covers things like injuries at our common areas. We also have directors and officers liability insurance that covers us for essentially the decisions of our board of directors, your actions. Very broadly, of course, not advice to any specific community, because we know your policies will differ, but it is common for our general liability policies to have some version, they use different terminology, but some version of an exclusion to coverage for communicable disease issues. And that means in many of our liability policies, we may not have insurance coverage for a claim by somebody who may get injured, infected by us operating our amenities. Now, certainly there may be ways to defend that we've satisfied our duty by doing all these protocols. But we may have situations where we have policies, general liability policies that might have exclusions. On the other side, at least in the ones that I've reviewed, we believe that most D&O policies still should cover our defending us in liability on a decision to delay opening while we evaluate what's happening in the world and our community. So the reality is we may have insurance coverage for waiting, but we may not if something happens and we open. That's certainly a reasonable consideration in the decision on when to open. Second for me is if we are evaluated, reviewed by the courts based on the reasonableness of our decisions, or are we making decisions arbitrarily? And if so, that could create liability for us, breach of our duty. Well, I believe it's much easier for us to defend that our decision was thoughtful and meaningful if the decision is one where we can say, look, we didn't jump to open the first day Governor Kemp allowed us to open because above all else in the world, our people need recreation. But instead, we're able to say, look, we understand the competing interests and that we absolutely value and want to have amenities available to our people. But we also waited specifically so that we could watch what happens in those other communities that we know open immediately, or to see if there are any changes in the orders from health department, CDC, or Governor Kemp. So there's no magic date, but certainly I think it's more reasonable for us to look to, no earlier than Memorial weekend or June, so that we have an opportunity to watch than to open this Saturday. Of course, we know we'll have boards that want to do it, and then we implement the protocols and put up the signs and disclaimers and everything else we possibly can. But it's certainly a risk, and I think both of those are very reasonable considerations for when we open, and leads all of us here, we all have the same answer, which is opening right now, probably not the safest thing to do. It certainly makes sense to wait and see what happens in other openings. Okay. Jamie is going to talk about some of the other real life issues we have going on in our world that we need to be thinking about. And some of you asked about these, And here we go. Jamie?
I know you guys are very impressed that I kept my mouth shut for that whole time. It was
Almost all time.
I mean, I was really impressed with myself. Not all, I said it depends once. I do want to kind of shift gears a little bit. I know that everyone is pool, because that's what all the boards are talking about. I'm on Facebook. I'm seeing all these different women and men in different neighborhoods asking questions about pools. I know that's going on. What I want to do is shift gears a little bit because I know this sounds insane, but annual meeting season will be here before you know it. And annual meeting season this year, I think specifically, is probably going to be exclusively online, meaning some type of electronic platform for most meetings. Whether or not there are governor's orders in place again at any point in time, I think most people are not going to still be comfortable in large groups. And that's going to mean that you end up probably looking at an annual meeting that's going to end up being online. We have hosted actually a number of annual meetings online for some of our clients in the past couple of months, and it becomes extraordinarily cumbersome to do all the check-ins and any type of voting actually at a meeting that's online. You've got to have everyone's faces up. People have to vote in person with their hands up, and you have to start counting everybody. Sometimes, like on our platform, we've hosted a couple meetings. You can do a poll or a chat so you can take votes that way, but counting them and figuring out who wins and what the end result is, very, very difficult, very cumbersome. So what we've suggested, and what is working much better, is to have any type of vote outside of the meeting. So if you're going to be electing directors, if you are going to be voting on a special assessment or an amendment or any other type of action, it is easier to do it outside of the meeting, electronically or in writing, but not during the video annual meeting. The reason why I really wanted to bring this up now is because if you are going to be working with a board to do electronic board elections, you're talking about typically a 2 to 2.5 month leeway. So you figure out when your annual meeting is going to be, and then you back end into some of those dates, which is you start essentially the process about 2.5 months earlier. That means if you're planning on an annual meeting sometime at the beginning of October, we're talking about starting the process for annual elections sometime at the beginning of August. Well, if that's the case, you guys need to be working with your boards of directors essentially now in June and July to be acclimating them to this process and talking about what the timeline is going to look like, and then preparing the timeline and the documents to get ready. And essentially what has to happen is you need to explain it to everybody in some written format. You need to ask for nominations. When people nominate someone or themselves, you need to collect biographies. You need to send out those nominations with the biographies with the annual meeting notice. You need a block of time for collecting votes and tabulating those votes. And if the association's never done this before, you actually have to also build in more time to allow the members to figure out how to register on the third-party voting website, what that process looks like, and how to implement the voting procedures. So we're talking about building in time at each step of these timelines for an annual meeting that might be in October, but really needing to start much earlier. So I wanted to just make sure that you guys and your boards have it on your radar screens, because it's going to happen quicker than you think. And if we're playing catch up in the middle of the fall, it's going to be much more difficult than if we're thinking ahead to where we want, what we want this to look like, and get everybody prepared to make that happen. So that's sort of my little teaser on get everyone ready. And of course, we can help you with all these documents and all the letters and putting together the timeline. We're happy to meet with your boards and with you about kind of putting that together. So.
Thanks, Jamie. And we've been talking about this years, that
Yeah.
this is definitely the way of the future, that at least the election part should be pulled out of the meeting. It's so much easier. And most communities legally can do this.
Oh, yeah.
So it's important to start talking to your boards about this. Okay, next issue. Something that scared me a lot recently, right before the pandemic, that impacts all of us, is a case that, Georgia appellate case that came out earlier this year, Abdullah versus Winslow at Eagles Landing, that might throw our world into a free fall. It was a case regarding fines. And I'm going to probably embellish the facts on this a little bit, like I do on most stories, to make it sound better. But this is mostly accurate. So what essentially happened in this case is a community that has covenants that specifically says the board of directors can levy fines for violations. Find an owner for some violation, yard maintenance and statute and other things like that. Owner challenged it. This actually went up to the Court of Appeals. And the Court of Appeals essentially said this, that the declaration said that they can fine, but the declaration did not say that the fines may be or will be $100 per violation or something along those lines.
There's just no dollar amount in the document.
So this fine is invalid. You cannot fine. It's not enough to say that you can fine. Now, and I think this is because we have friends at the Court of Appeals who understand our world. They actually threw us a bone that they didn't need to. And they said, this would have been different probably if the community had published policies, regulations saying, if you commit these acts, these can be the fines that you're subject to. And I think they were thinking about what we see in our world all the time. You pull into the parking lot of a Publix and you see the towing sign and it says, you may be towed and the fee may be $125. Court of Appeal said specifically, there has to be some policy that owners are aware of so they have an expectation of what the consequence could be to their violation. Otherwise, we're not going to let you do it. So they have said what, frankly, is probably common sense anyway. Every single community must adopt resolutions, policies, talking about what our fines going to be, our fines will be. And I think we can be broad with those. You definitely need to talk to community lawyers on what that should look like. But this is a very easy fix to what could be a huge problem. We must have policies that we publish to the community that tell people the possible consequences, the ranges of fines for their violations. Okay, we definitely need to get back to that quickly.
Just want to clarify one thing for that. Those policies can be prepared usually by the board and passed by the board. It does not necessarily mean an owner vote to establish the amount of the fines, but someone's got to create the fining schedule and send it out and give notice to the owners of what their consequences are.
Absolutely. And we know how our industry works. There are lawyers out there who represent owners.
Yeah.
They know about this case. This will be how they defend all of our actions against people who are violating our covenants.
Absolutely.
And it's such an easy fix. We just need to do it. Make sure you tell your boards.
Got it. Last thing we want to bring up to you is also something that I think kind of got swept off to the side with the pandemic, but it's extremely important and it's an issue that's come up 9 gazillion times. It's about emotional support animals. And there are new guidelines that HUD published in January of 2020, just a couple months ago. I don't think there's been a lot publicized about this issue, but it's really important that kind of everyone gets on the same page because we're in a much better place than we were before these guidelines existed. Essentially, the guidelines were put in place to address the ambiguity that we saw regarding documentation necessary by owners for assistant animals. And HUD literally said they want to make sure that there is a way to address people who do not have a disability, but are simply trying to avoid costs, avoid guidelines, just because they want a pet. And the guidelines basically recharacterize the types of animals that we're talking about. Essentially, they're now talking about assistance animals as sort of the umbrella phase. The umbrella word, the umbrella phrase being used. And there's 2 types, service animals and support animals. So instead of calling them emotional support animals, HUD is now just calling them support animals. And there are literally just 4 things I want to bring up to you. The first thing is that if the person's disability is not readily apparent, we are entitled to find out from the owner if there is in fact some type of disability that requires them to need an accommodation. We are not required to tell them, or even allowed to tell them, this is the documentation we must see from you to show that you have a disability for which you need a support animal. But there is an exceptional appendix to the HUD guidelines, and I can get you that link very easily. And the association is supposed to say to themselves, do we have documentation from this owner about whether or not they have a disability for which they need a support animal? And if the answer to that is no, the new HUD guidelines encourage the association to say to the owner, listen, go to this website, look at these guidelines, and provide us with documentation. So the second thing I want to tell you about this is that HUD guidelines specifically address the concept that internet documentation, the $35 certificate that you buy, is not in and of itself sufficient to establish that a disability exists for which an owner needs an accommodation for a support animal. Hallelujah.
That's huge for us.
It's huge, and it's literally specifically addressed in the guidelines. Again, they tell you as a housing provider, the association, when this happens, tell your member, tell your owner, go to our guidelines, look at what documentation should be presented, and let the owner figure out how to present that documentation to you. But internet documentation, not necessarily the only thing needed. Third thing I want to tell you, which is also great, except for extremely rare circumstances. The new HUD guidelines specifically explain that we only have to make accommodations for animals that are typically kept in a household. So no more giraffes allowed in our community associations or hippopotamuses. The guidelines actually, the appendix that I'm talking about, specifically lists certain pets. And I'm going to read them. Dogs, cats, birds, rabbits, hamsters, gerbils, fish, turtles. Those are the typical examples listed as normal household pets. So if an accommodation needs to be made for a different type of service animal that is not normally in the household, that's a whole different analysis. And we're allowed to say no, unless there's extenuating circumstances. Last thing, the fourth thing I want to mention is these new HUD guidelines from January 2020 are prospective only. We are not supposed to go backwards and look at an owner and say, oh, we approved something in the old guidelines and now they wouldn't have to be approved today, so we're going to take away your approval. We cannot retroactively go back and tell people you're no longer approved for whatever support animal we approved before, which is the same for almost all circumstances for approvals of any other type of architectural issue or something else. So that was sort of the four things I wanted to bring up. Way more detailed information, and we're happy to give legal advice and opinions to our clients about all that kind of stuff and how they should handle it from now on.
Great, thanks, Jamie. Mention your class. Jamie?
Oh, mention my class. Okay, so I don't know if you guys know this, but next week on Tuesday the 19th at 10 o'clock, I am hosting a webinar, which is going to be a free 3-hour CE license law class. The class will give you 3 credit hours for the Real Estate Commission, but also specifically meets the Real Estate Commission license law requirement, which has been renewed for the next 4 years of your license renewal period. So please join us. We have about 200 people signed up already. And if you're not one of them, please come online and sign up. Jason's the person to communicate with, and he'll get you ready.
That's awesome. Thank you, Jamie. So thank you, everybody. We're going to keep the session open. Jamie and I will sign off, but for 2 more minutes so you can continue to send in questions. We'll try to get to everybody after the session with the questions. Thanks for doing that. We miss you guys. We hope we get to see you soon. Stay safe, everybody, and take care.